What I wanted to ask you, just kind of switching gears from expectations, just your experience in the hearing itself, your perspective on how you, or maybe some of your colleagues, but how you approached figuring out the truth. And is this person disabled? Are they telling me the truth? Credibility, like what were things you looked at, and any specifics or examples you could give us, that would be awesome.
Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA Disability Guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode.
What is the most amount of hearings as an ALJ you've ever done in a month?
I like
That
doing,
heard of being done, maybe. Let's
Yeah.
do that. What's the most amount of hearings you've ever heard of being done in a month?
I don't know.
Uh.
I don't know how other people did. A lot of my colleagues, not a lot, I'll just say some of my colleagues would monitor, what is their disposition rate compared to other people in the office, other people in the region, and we could measure that. What is my, how many favorables am I issuing and unfavorables, that sort of thing. And some people monitor that very closely, but I didn't, because I just wanted to do the best I could. I didn't want to be influenced by competition or, I need to be closer to whatever percentage of, fully favorables versus unfavorables. I just wanted to do my work and not be influenced by those things. So I'm not quite sure I'm sure there are people hearing a massive number of hearings per month, but I don't know. I don't know. For myself, I liked hearing cases. And so I would typically ask for a certain number per month and be scheduled for a certain number. And I might get fully scheduled, or there might be a gap of, maybe, but I might typically schedule 50 hearings in a month and be scheduled for 45. And again, it all depends on receipts. But what I would do, because I like hearing cases and helping out, sometimes people get sick. Sometimes people have emergencies, and there'll be a last minute hearing request, and it could be anywhere in the country. And I would take those and pick those up. So for me, I don't know. I think I don't want to do too many in a month, because you want quality. You want to do a good hearing. You don't want to be exhausted. Probably, I think maybe the most I ever did was maybe 55 to 60 in a month.
The most amount of hearings I've done in a 6-week period is I did 72 hearings in 6 weeks, and I was done. The week 7, I was
Yeah.
week off. So
Oh my gosh, how did you and that's it. Don't we learn from those experiences? Because there's been times, because for me, scheduling, and I don't know if you feel this way, but there were certain things that were challenging for me, and to the very last day. And one of them was scheduling. Do I schedule a big cluster of hearings? Do I do them 2 days a week? And what's the best? And it's with always the idea that what is the best thing for the claimant? I might think I'm doing okay, but after one full week of doing let's say 9 hearings a day for 5 days, because I used to do these clusters, I believed I was still doing okay, but maybe you got to pace yourself. Like, did you feel that way after your 72?
I felt like I did a great job on all the hearings. I don't think I burned out on week 7 where you're like, I can't do any more hearings, so we have to have someone else do them. But just I needed like a few days off. I was working night and day, kind of round the clock. It was right when the pandemics kind of they let phone hearings. And we're like, yeah, we'll take all the phone hearings you want to give us. And I shouldn't have said that. I should have said, let's limit, the number of phone hearings. But at like 8 a.m., or actually, frankly, before that, it'd be like a 5 a.m. hearing because I'm repping someone who's on the East Coast, and they wanted, and for them, it's, 8 a.m. And then I would be, okay, a Portland hearing phone and then a Chicago hearing phone. And then it was sort of this back to back. And it just got a little bit much, but I learned a ton from it. Lucky, I mean, and we can talk a little bit more about your experience, and because I think the hearing is, I explain it to clients, the hearing is sort of the crescendo, or the concert. It is not the creation of the song. It is the practice to get to the concert. It is so it's so important to be able to read files and to be able to, and a lot of judges will ask reps for an opening statement or their theory of the case, and then each judge is a little bit different on how they want that, or they'll ask for an opening memo, or they'll ask for a closing brief, or, a closing argument. So everyone's a little different. And I do believe most ALJs fully expect us reps to know the file inside and out. So it's like, hey, if I have a client who is testifying about something that the judge did not see in the record, they're just going to turn to me and say, where your client's talking about, diabetes, and I didn't see that diagnosed. I didn't see that. Mr. Evans, do you know where that is in the record? And I need to be able to answer that question. Yes or no, but I need to be able to answer that question. And so it becomes really, detailed notes and prepping the case for me. I don't have a photographic memory, unfortunately, but, detailed notes and having those kind of, okay, where's the MRIs? Because often, where's the objective evidence that proves this? What does that say? What exhibit, what page number? I'd be ready for what I could predict might be a question in the hearing. But yeah, so prepping the file was the most of the.
That was exactly prepping the file. And also you're working with your client as well. And that's an important piece. And when a judge appears for a hearing, that, they're reviewing the file too, ideally, and preparing for the hearing as well. But the piece of working with the client in advance, I mean, we hold the hearing, and that can go anywhere from, it depends on the judge and it depends on the case. It can be very lengthy or it could be 15 minutes. It just depends.
Ah.
And but you've got that piece and it's important, to meet with your client and to walk them through what to expect, and because it's an important event in their lives.
One last question about kind of just expectations from higher ups, and I do appreciate you answering the question. So and I think I know the answer, but for the benefit of our audience, like, is there any pressure from the higher ups within Social Security to either award a certain level or deny a certain level?
Not that I ever experienced. And
the judge I've ever talked to, like, no,
I just never experienced that. I feel like my management chain there's a hearing office chief administrative law judge. There are regional chiefs, and there's been, in the year 2025, like a reorganization, if you will. So they still exist, but just not as many.
Right.
We still have regions, and then we have our headquarters. And so there's a management chain. And I, throughout my career, found that my management chain from the top to my frontline supervisor were incredibly supportive. And so I was very fortunate.
That's awesome. That is great. What I wanted to ask you, just kind of switching gears from expectations, just your experience in the hearing itself, your perspective on how you, or maybe some of your colleagues, but how you approached figuring out the truth. And is this person disabled? Are they telling me the truth? Credibility, like what were things you looked at, and any specifics or examples you could give us, that would be awesome.
Mm. Well, I think that in the beginning, it was, when I was learning the ropes in those early cases, there was, the a checklist of items that I would go through, and that was fine and necessary. And I think as I continued and became more seasoned in the work, it became more of a conversation with people. And so I have this idea of what the sequential process looks like, but it might be just through this conversation that something comes up about work history, about why they left a job. Well, let's talk some more about that. Let's dig a little deeper into that. It might be something that comes up about their manipulative limitations, what they're able to pick up, or they're dropping things, or they have a particular challenge, say, in with being around others. And it became more of a conversation. And also, I might get the ball rolling, and I would have questions, some select questions, but typically I would ask some introductory questions that started things out. And then the representative performed a critical role, because then they would take over and ask the very more specific questions. Now, it's through their line of questioning, I might hear something, or either through the representative's line of questioning or the claimant's answer to those questions, I might pick up something, and that gives me an opportunity to continue the conversation and go a little deeper. But I found early on, I don't know if I had control issues or not, but I wanted to ask all these questions, and I have my checklist, and great, it was great. Covered things, and then the representative will come in with their questions. But I think as I became more comfortable in the hearing process and with the law, uh, it was more conversational. And I'll tell you though, the representative always plays a critical role, or at least in my hearings, they did. Yeah.
What was the format of your hearings when you did them? Do you like let's the claimant and the rep walk in, or they're by phone or video? I know you do an introduction, like, hi, I'm your judge. And then do you go right into questioning? Do you do opening statements? What was your format?
Well, for me, I would start out the questioning. So I would start out by, we're going on the record, and then mention everybody who's at the hearing, introduce our hearing monitor, our vocational expert and such. Here's who's present. Then we would go through exhibits. I'd talk to the representative. We would probably discuss any outstanding evidence and a timeline for getting that in. And I always took notes. Not every judge is this way, but we have a system to record all that. So that way my support team would know we need to we're waiting for some medical records, 2 weeks, so I'm recording all that. Then I would swear in the participants. I typically swear in the vocational expert and the claimant at the same time. And sometimes we have a medical expert, but that happens, less, I would say maybe 30% of the time. It's not, but vocational experts were always with us in my hearings. And I then would start with the claimant, and I would just start asking, what's the highest grade you completed in school? Did you, if it's not graduation, I'd ask about a GED, and then I would turn to work history. And now we go back 5 years, which I'm thankful for that. I'm so
It's like easier. Yeah.
Well, it's a poor claimant having to remember back 15 years ago. So, I'm glad that we go back 5 years now, and so we'll just talk about it, but that's rich territory, because often there's trouble, especially in that last job. physical troubles, maybe some mental health challenges that make especially that last job difficult. And this is where my training as an ALJ with the state came in with work separations, and so we talk a little bit about that. And then unless I would turn it over to the representative at that time to get into the nitty-gritty of the physical because as you said, they have worked with the claimant. They're professionals. They have spoken with the claimant ideally a few different times before the hearing. And so they're going to dig in and they're going to help me focus my attention. I usually know already due to my preparations, like the medically diagnosed impairments, but then there might be that manipulation. That's going to be a big one in this. And so I know that going in because of my own preparations, but let the representative represent. So they would dive into the questions and I might have follow-up then based upon that conversation they had with their client. And then we would turn to the vocational expert. I would take the lead with questions with them. I'd pose what are called hypothetical questions to the vocational expert. And then the representative has an opportunity to ask questions of the vocational expert as well. I didn't take opening. I would do closing. And I would just say, is there a closing? Some people, and usually that was fine. I understand that we need to do a closing. There's a requirement for that. And I might be mistaken, but I always like to give, it's optional. And I would say an optional closing. And sometimes people had them and sometimes they didn't, but I like to give an opportunity. And then there are times too where there's something quite relevant for me to know in the beginning of the hearing. And the representative will, do their best to interject, say they're amending the onset date, for example. And so that might be done, less formally at the beginning of the hearing.
Yeah. Were you ever persuaded by a closing argument from a brilliant attorney that just tuck you from like, okay, I'm not going to pay this case to, I mean, obviously you don't have to say me, but if you want to, I won't.